Hello and welcome to Criminal Justice in a Nutshell. My name is John Fisher, and today's topic is police and the law. What we're going to focus on primarily is the Fourth Amendment and arrests and the legal aspects to making an arrest. There are two types of arrests. There's the arrest by a private citizen, and then by a law enforcement officer or an officer of the court who has an order uh, to go. So I guess three types of arrest. There's the private citizen arrest, the law enforcement officer arrest, and then the arrest pursuant to a court order. First, let's briefly look at the private person or the private citizen arrest, more commonly known as a citizen's arrest. They're very restrictive in nature, although there are thousands made every single year. It's excuse me, primarily made by security guards who apprehend or they stop somebody. So I guess right now what we need to do is define what an arrest is. An arrest is the lawful detention of an individual. Okay, so granted, we watch on TV and we watch all over the place on, yeah. Have you been arrested? No, I've not been arrested. I've not arrested him. He's not been arrested, blah, blah, blah. And we see it constantly. An arrest is from the French and it means to prevent movement. So the minute the police officer turns on his lights up above and pulls you over, he has stopped you. In legalese, that's actually a detention because he's stopping you for a purpose. He's going to conclude a further investigation. But in reality and in truth, that is an arrest. Once you are not allowed to have the freedom of movement, you have been arrested. Okay, this doesn't mean that Miranda has to be given right away, and we'll get into Miranda in a little bit. Okay, but most private citizen arrests are accomplished, they're completed by private citizens, mostly security guards. There is one drugstore chain. I'm not going to mention the green walls of this drugstore, but they make on the average of 12,000 arrests every year from people stealing from their store. This store that I'm not going to mention, but does have green walls. Um, so anyway, most crimes are shoplifting. They're illegal trespassing. They are must be committed in the presence of the arresting person. Okay, so I know Walmart has a policy of not stopping somebody once they leave the store. Okay, if you can get out of the store, their security guards and their loss prevention officers will let you go. They do their best to try and stop you in between the doors. You know, they've got that Sally port, those two sets of doors. Because once you leave that first set of doors, you have no intention of going through the cash register to pay for things. Okay, a felony must have been committed, and the arresting person should reasonably believe that the party they're arresting has committed the crime. That's not necessary. Most detentions, most arrests by citizens are for misdemeanors. But Legrand versus Beddinger defines an arrest as follows. The term as arrest is derived from the French, like I said, arrester, and it's depriving a person of the liberty and binding him to become obedient to the will of law. And that's the definition I've already increased. One thing that must be involved with all citizens' arrests is that probable cause must exist. Okay, there in Abilene a couple weeks ago, my brother-in-law was telling me about this, that some guy walked into the HEB there in Abilene and pulled a gun on the cashier and said, "Give me all of your money." What he didn't realize was there was a person standing behind him in line that also had a firearm, pulled his firearm, pointed it at him, said, "Put your gun down, you're going to jail." And the bad guy goes, "Well, I can kill this clerk before you can pull the trigger. And if you shoot me first, you're going to go to prison." And somebody in the next aisle over also pulled their gun and said, "I'll tell you what, why don't you just put your gun down and we're going to wait for the police to show up. It went according to plan. The police showed up. Bad guy was arrested, put in handcuffs, brought to jail. These two individuals committed, or they concluded they committed what's called a citizen's arrest. Now, the arrest by a law enforcement officer, there's two types of arrest by law enforcement officer. The first is in the presence of a law enforcement officer, and the second is by following court order. A law enforcement officer is anyone who's employed by a branch of government with the authority to uphold the law. They are given a badge and a gun and arrest authority. Technically, the only police officers, the only law enforcement officers are local, which would be municipality, county, and state police. Policing is a state's right, it's a state's power. The federal government has no authority to arrest anybody unless there's a legislative branch. So the FBI, the CIA, the NSA, the DEA, the ATF, and all of the rest of the alphabet soups, they're special agents with special arrest authority. Technically, they're not supposed to operate in any community without the permission of local law enforcement. And so if, for example, a couple months ago, we had the militia take over that federal bird watching house in Oregon, and the FBI showed up. They did not coordinate with the sheriff's department. They just took over. They said, this is what we're going to do. Technically, that's a violation of the Constitution, but who's going to complain? Who's going to go to war with the federal government? Okay. An arrest, to obtain a warrant, two things must be present. And I know that the learning objectives say three things. But to obtain a warrant, you must have evidence that, or probable cause to arrest. So you need probable cause. You need to know that a crime was committed, and the person to be arrested or commit the crime needs to be placed on an arrest warrant. A search warrant requires the person, place, or address to be searched, the item to be seized, and the probable cause to do that. So those are the three things needed for a warrant. The crime, the individual, and the probable cause. Arrest without warrants, these are the very most active, most common form of arrest. They've always been authorized under common law. However, the Supreme Court has stated that a police officer must be present during the crime to make an arrest without a warrant. The Supreme Court has stated that warrants for every arrest is impractical. Okay, if I'm going to 7-Eleven down here on the corner of 4th and Birdwell, and I have my badge on my belt, and I'm carrying my gun, and I'm wearing my coat, and nobody knows that I'm a cop, and there's an armed robbery going on, I can make an arrest without a warrant because I witnessed the crime. I'm an officer of the law. I am employed by the city, county, and state of Texas as a law enforcement officer. And it's my job to arrest people when they commit crimes. If I see them committing the crime, or there is some other exigent emergency circumstance, I can arrest somebody. Okay. I don't need a warrant. I can even go into your house. Okay, say George Jones is DWI again for his 95th time, and he gets out of his car and he runs into your house. I can follow him into your house to arrest him because I watched him go in there. I don't need a warrant to chase him into your house to arrest him. Okay, the officer is a witness to the crime. I would be a witness to the crime. I don't require a warrant. If I believe that the police had to wait for a warrant, the suspect would destroy evidence or disappear or escape. A warrantless search is also authorized. Okay, so an arrest with a warrant is always the legal preference. We always want to prefer that there is a warrant to make an arrest because that gives us qualified immunity. Okay, at any time that we're working under the auspices and the commands and the directions of the court, we are immune from prosecution because we're following orders. Okay. The arrest warrant is written in order and issued by a judge, and then we are operating underneath his absolute immunity, and we cannot get arrested, go to prison, or lose our jobs, or even be sued because we're fulfilling a warrant in good faith. Warrants do require the following information: a caption or a title from the court that's been issued, the name of the person to be arrested, the description of the person to be arrested. You know, a couple of months ago, police came to my front door and knocked on the door and said, "We're here. We have an arrest warrant for John Fisher." And I wasn't home at the time, and my wife goes, "I don't think so. You don't have a warrant for my husband's arrest." She goes, "Well, John Fisher." "Yes, that's my husband's name. He's at work. But there's no warrant. You're confused." And they go, "Well, the John Fisher that we're looking for has this description, and he's 25 years old." And my wife goes, "John Fisher is 49 years old, and this is what he looks like. He's 6'3". He's 280 pounds. He's got brown hair, brown eyes. He wears glasses, and it's rare that you ever see him without a hat on. You're not looking for my husband." And then they looked at the warrant and they saw that they were right. They weren't looking for me. Also has to have a signature of the judge and a command within the warrant to arrest. Okay, just because you've been arrested does not mean that Miranda has to be read to you. And you see that on Hawaii 5-0, "Book 'em, Dano," and then Dano goes, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be appointed to you by the courts." Okay, that's the Miranda warning, and hopefully you understood it as it was being read to you. But it's not required. The only time law enforcement, or the only time anybody is required to read you Miranda, is if they are going to ask you questions about the crime. If they're going to talk to you and they're going to initiate conversation about your involvement in a crime that could be used against you in a court of law, that is when they need to read you Miranda. Other than that, they don't need to read you Miranda. Stop and frisk in 1967, Terry v. Ohio, or 1968, Terry v. Ohio, authorized stop and frisk. If I, as a police officer, have articulable reasonable suspicion, I can stop you and I can search you for weapons. There's 8 points that Terry v. Ohio has covered, and I'm not going to cover them all. You can read that in your textbook. A temporary detention is just that. It's a mere detention for questioning. It's not considered an arrest because they have no intention on removing you from that place. I want to talk to you about what are you doing? Where are you going? Why are you hanging out in front of Pinkies? Okay. People versus Campbell and People versus Gonzalez state that a detention starts once a police officer turns on his lights and directs a person to pull over. If the car is parked and the officer asks for a driver's license, it's not a detention. It's now an arrest because you can't leave because you're not supposed to drive without your driver's license. Okay. So when you ask that police officer, "Are you arresting me?" and he goes, "No, I'm not arresting you. I'm going to give you a ticket." "Oh, you're going to give me a ticket in order to appear in a court. So this is a summons to appear in a court." "Well, yes, I'm going to give you a summons. You're not pleading guilty or anything like that." This is a big debate, but the difference between an arrest and a Terry stop, or an arrest and giving you a ticket, is the length and the detention is considered. If you say, "Can I leave?" and the police officer says, "No, you cannot," you are under arrest. This is John Fisher. This is Criminal Justice in a Nutshell. Today's episode has been police and the law, but primarily it's been, have you been arrested? John Fisher, signing off for today. I hope you have a very fun day.